This video lecture will cover Chapter 2 of our textbook, Legal and Ethical Issues in Counseling Adolescents. Our professional ethics speak to the need for protections that are specific to children and adolescents. When we work with young people, we rely on legal and ethical principles that are unique to them when we compare our work with adults. We have to make clinical decisions that are complicated by a child's limited legal rights and an ethical imperative we have to keep those kids safe. At the same time, kids of all ages are capable of making developmentally appropriate decisions and benefit from some autonomy and personal agency in their mental health treatment. Maintaining this balance requires that professional counselors have an extensive and specialized knowledge and skills base related to legal and ethical decision-making within the specialized population. So in nearly all classes in the program, there's a chapter or two focused on legal and ethical issues. So we're very well versed in these issues. In this class, we'll be looking at legal and ethical issues through the lens of working with adolescents. We're going to look at some things that are different ethically when we work with adolescents than when we work with adults. For instance, an ethical obligation for counselors of children and adolescents that is not an issue for counselors of adults is parental notification or involvement when that child is receiving treatment. This also leads to another difference between child and adolescent versus adult therapy: identification of the client. Who is the client? The parent may be considered the client because they are legally responsible for that child or adolescent. Counselors also may have varied personal ideas, attitudes, and opinions about certain topics, such as parents' rights and then divorce, adolescent sexual behavior or adolescent substance use, and breaking confidentiality. We may still have these opinions or attitudes when we work with adults, but we separate them from our work with adults. We have a boundary, and we work with our adults without judgment, and we approach them with an accepting attitude. But when these issues come into play with adolescents, we may have to tell the parents. We have to decide where is the line of adolescent sexual behavior that you feel like you have to notify the parent. Is there a difference between a 12-year-old engaging in sexual behavior and a 17-year-old engaging in sexual behavior? At what level do we feel like we have to let a parent know about substance use? We may be dictated to by the court as far as who can and can't be involved in treatment if there is a divorce or a separation in the parents of the adolescent. So these are all things that will come up when we're working with adults. And we're going to talk at the end of the lecture about ethical decision making. But these are some really good questions to ask yourself if you feel like you're in a dilemma. What is your relationship to that client? What is your obligation to the client? How does your own experience influence the decision that you are making? Your own personal beliefs, your own opinions, your own personal history. Should you consider it from another perspective? The child, the parent, the sibling. And if you reconsider the issue from an alternative perspective, How might your decision be modified? Let's begin by talking about the rights of minors. So children have fewer rights than adults, but they are protected under federal and state laws. And they're considered to have civil rights and many other legal rights that have been designed to protect them. And we have talked about some of those, such as child labor laws. Laws related to what constitutes abuse or neglect, issues of age of consent for medical and mental health care services, statutory rape, and minors' access to reproductive health services varies from state to state. And I've included the link here from the textbook. This is a great link to bookmark to look up laws and policies particular to your state about these issues. For instance, there are 36 states in the United States that allow individuals as young as 17 and sometimes younger to marry. So if you were to have an adolescent client, 15 or 16, come to you talking about getting married, you might want to know, is that legal in the state? At what age can an individual consent to marriage? Is there a restriction on the age difference between the person my client is planning on marrying and how old my client is? So this is a great resource because it does vary from state to state, and these laws change from time to time. So you always want to have a resource to go look things up to double check when you have questions. Let's talk about some specific laws that have been enacted to protect children and adolescents. So HIPAA. Everyone knows HIPAA. Protects the privacy of medical patient health records, and that includes mental health records. That's HIPAA. FERPA provides confidentiality of student records and covers any school that receives federal funds. And within this confidentiality, that would include any documentation related to the Individuals with Disabilities Act, and that may include psychological/academic assessment, report cards, that may include a 504 plan or an IEP, which is an individualized education plan. There are additional protections in the form of 42 Code of Federal Regulations Part 2, which applies to privacy of records related to substance abuse education, treatment, or prevention programs in which a child or adolescent may engage. So HIPAA and VERPA both provide confidentiality and privacy as far as records go, whether it's medical or educational. They both, though, allow legal guardians to obtain their child's records. So through HIPAA, a parent can obtain their child's medical records, and through FERPA, they can obtain their child's educational records. In some cases, HIPAA allows for minors the right to keep their health records confidential from their parents or caregivers if the minor is able to show that releasing records to caregivers would put them at risk. This is where things get complex because HIPAA is a federal law, but the age of consent for treatment will vary from state to state. So what is considered a minor in one state may not be considered a minor in another. And so this is where we get into consulting with our colleagues, consulting with our professional association, attending lots of different trainings to try to stay up on this as much as possible, reading articles to be able to know how to navigate these difficult situations. A minor's legal consent. Consent is the ability to enter into binding contracts, and this is a right afforded to adults. With few exceptions, minors cannot enter into legal binding contracts, and this includes counseling. While it's generally understood that the age majority is 18, state laws vary concerning at what age individuals may provide consent for their health care. For example, in many states, adolescents can consent to treatment. The legal precedent is often whether or not the adolescent is of age to make mature decisions, or if disclosure to parents or caregivers would put the adolescent at risk of harm. This actually was an issue for me in my practice in the past 2 years. I had an adolescent female call and want to make an appointment for services at the age of 16. There were complicating factors also as far as who her guardian was, because her grandmother was raising her, not her mother. And this had been the case for years. However, there was no formal legal documentation for this. It was an informal familial agreement. So, but let's remove that part. Let's just say, let's take that part away because that just made things more complex. So to figure out whether the 16-year-old was able to consent legally in the state of Kentucky for services, I contacted my professional association, and they weren't sure. And I contacted 2 different attorneys whose area of knowledge is in the focus of healthcare, whether that be physical or mental health care, with a focus on ethics and legal difficulties. And neither of them could give me a straight answer as to what the age of consent was in the state of Kentucky, which was very frustrating because if I made the wrong decision, I could really put myself into some hot water, and none of the quote-unquote experts could guide me. So I was really at risk for making a wrong decision. So that felt kind of scary. I was finally able to get the guardian to give consent just to cover everything, cover every base. If the guardian hadn't wanted to do that, I would have continued to consult to figure out my next direction. But luckily I was able to get her in there, but it was frustrating not to be able to have a clear black and white answer of yes or no. The hard part is if you have an adolescent and they are allowed to, let's say, consent for treatment at the age of 16, if they want to use their parents' health insurance for services, there's really no way to keep the fact that they're seeing a therapist away from the parents, because the parents are going to get EOBs from the insurance company that indicate that their child has been to see a healthcare provider. So this gets sticky. It hasn't happened a whole lot. I've really only had so far this one time where I had this very independent young woman who wanted therapy and pursued it on her own. Her family wasn't against it, but they were not going to assist her in any way. They thought it was kind of silly. So they weren't going to stop her from having therapy. They weren't going to help her either. So these are the things that can come up when you're working with adolescents that really are not going to come up when you're working with adults. So even when minors cannot consent legally, they're not going to sign the consent for treatment form at the intake session, they can provide assent. And that's when we engage in informed consent with them. We can tell them this is what therapy is, this is what therapy is like, this is what you're expecting to do, and this is what I want to do as a therapist. Here are the limits of confidentiality. Here are the things I'm required to report. What do you think about that? How do you feel about that? And engage in a conversation. If we flip it from an adolescent who wants to come to therapy and a family who's not supportive, we can see an adolescent who doesn't want to come to therapy, but their parents are making them. So they haven't offered consent, and they haven't offered assent either. And I've only had this happen a couple times, and do have very resistant adolescents come in from time to time. And then all, so far, fingers crossed, but about 2 cases, I've been able to engage in some kind of relationship and therapeutic intervention with these adolescents. I've had 2 female adolescents over the years. Even when I asked, I know you don't want to be here, I see this in the intake session, what I ask is that you give me 2 more sessions, that we have 3 sessions in full, so I can have a full assessment of what's going on. If at the end of those 3 sessions you absolutely feel like therapy is not for you, we'll make a plan from there. And like I said, that's always ended up working out for me. I think giving the adolescent that autonomy to know that they have a say in whether or not therapy will continue makes a big difference. Ethically, I feel very, very uncomfortable with the prospect of forcing an adolescent to engage in therapy, or even just to be brought to therapy, because they can come and sit in my office with their arms crossed for an hour and not talk to me. Informed consent involves 3 aspects that we communicate to the parent or adolescent. Knowledge, so the client or parent knows what they're consenting to. That's on our part. On their part, competency or intelligence, the ability of them to understand the knowledge I've given them and the ability to make that consent. And then voluntariness, that you're doing this voluntarily. I'm not forcing you into therapy, and I'm not forcing you to remain in therapy. And what that looks like in informed consent is a description on treatment, risks, discomforts, and benefits, a description of other possible alternatives to the services being offered, an offer to discuss therapeutic interventions, and an offer to answer any questions, and making the client aware that they are free to withdraw consent from treatment at any time. Adult caregivers must consent to treatment for their unemancipated minors, as those minors do not have the legal authority to grant consent. Therefore, young people do not have the same reasonable expectation of privacy as do adults. The fact that they can't consent to treatment means that they are not the client. The client has confidentiality. The client is the parent has confidentiality. So again, we see where this makes things much more complex with adolescents. Adolescents may be reluctant to share information, like drug use or sexual behavior. The parents are responsible for this minor and are entitled to information discussed during the session. In order to best handle this, try to find a level of communication that is acceptable to both the parent and the adolescent. At the end of this lecture, we're going to talk about ways to make that decision. If a parent is asking for information, or if you feel like you have to share information, the best way to handle it. So this is what I say to adolescents and parents in my intake sessions. I look at the adolescent and I say, legally, you're a child. So your parents have access to your medical records. They have access to everything we talk about. And look at the parent and I say, however, when I'm working with an adolescent of this age, I ask that parents allow us to have confidentiality, knowing that if your child tells me they're going to hurt themselves, if they're going to hurt somebody else, or if somebody has hurt them, I will come to you and tell you that. And I don't think there's been a time yet where a parent hasn't agreed to that. And many parents are looking for that. They'll say, I just want her to be able to talk with someone. I want her to have complete confidentiality. I don't want you to tell me anything. So I tell the adolescent, if you tell me you're going to hurt yourself, or somebody else, or somebody has hurt you, or you're engaged in a behavior that I think is risky, that could hurt you, I'm going to come to you first and talk with you about it. I will not just tell your parents. So if I ever feel like I have to disclose something to your parents, you will know first. And we'll talk about it. And we'll talk about whether you want me to disclose it, or if you want to have a family session and disclose it. But it will never be a surprise. And that's the end of my speech. And this is where the gray area comes in. What is risky? Of course, suicidal ideation, suicidal plan or intent is risky. Absolutely, that is something that we disclose to parents. But what if an adolescent discloses that they smoke pot once or twice a month with friends? What if they disclose that they cut school one day? I could cite concerns about a risk to educational academic functioning and disclose to parents that their child cut school. I don't think I would. That's not where my line is, but everyone has their own line of what they're comfortable with, what they're okay with, what they think is risky, what they think is harmful. So again, that's where working with adolescents becomes more difficult. And if you've had me for other classes, you know I'm going to say, always consult. Consult with your colleagues. Consult with your supervisor. Confidentiality is the obligation of a professional to avoid disclosing information regarding the relationship with a client to any third party. Confidentiality is the legal rules and ethical standards that protect an individual from unauthorized disclosure of information. Privileged communication is a legal concept, and it refers to legal principles that protect information obtained in particular relationships. In this case, it would be counselor-client, from being entered into evidence in a legal proceeding. The privilege belongs to the client. So, I can provide information to the court if the client requests or consents that I do so. Privilege belongs to the client. If the parent is the client because the adolescent can't consent, theoretically, the parent can consent for me to provide information to the court about the treatment I'm providing for the adolescent. And that has happened at least once in the past 2 years. And that is a very tricky line to walk of complying with the court order, of maintaining my client's privacy, my adolescent client's privacy, maintaining a relationship with the parent who is putting me in a difficult position. So I pulled out an example of a time when a therapist was not required to disclose information about treatment. There are several specific incidents in the past 5 to 10 years where minors have successfully protected their records from either being presented in court or viewed by their parents. There's another one I have in mind, but I couldn't find it. But it was an adolescent who was able to go to court. I think the ACLU may have been his provided law services for him. But he was a 15-year-old or 16-year-old minor, and he was able to go to court and have the court find that his parents could not have access to his mental health care records. But this is another example. So the New Hampshire Supreme Court ruled that parents of minors do not have an absolute right to their child's therapist records, nor do they have an exclusive right to assert or waive therapist-client privilege on that child's behalf. So this was a case that involved divorce and custody. Dad felt like mom was alienating him from the kids. He wanted the therapist notes to prove so in court, so he requested those records and notes. The therapist refused to produce the requested information, as they were concerned that disclosing the records to Dad was not in the child's best interest. And this is where we have some standing as therapists. If we can prove or if we can defend our assertion that if I share this information, it will be harmful to the child, to the adolescent, that is a time when the court may listen and not require us to produce that information. So in New Hampshire, the High Court concluded that a parent does not have the exclusive right to assert or waive privilege, ruling that it's up to the individual trial court to determine whether that assertion or waiver of privilege is in the best interest of the child. These therapists would have had to refuse to comply with a court order or would have had to somehow communicate their reluctance to do so, which was very stressful. They would have most likely been working with their professional association and with some attorneys to figure out the best way to balance the ethical concerns. These therapists were caught between honoring the ethical standards of confidentiality for their adolescent clients and legal standards requiring them to comply with a court order. So let's jump from legal and ethical standards for counselors and look more at some of the laws that have been enacted to protect minors. So Section 504 of the Rehabilitation Act mandates that public schools, that federally funded schools, provide free and appropriate education to students who have a mental or physical impairment that limits one or more major life activity. This can look like education in a regular classroom, education with supplementary services or special education, and related services. Accommodations are related to providing access to educational services that help with a student's disability, regardless of that disability. It's important for us to know that because we may have to advocate for our clients. We may have to advocate that the 504 plan they have in place at school is adhered to by the school, that it is updated when it needs to be updated. We may have to advocate for the parent and tell the parent, this is how you can get this done. This is who you might want to call at your school. This is your right as a parent under federal law to have your own child have accommodations. Along those same lines, the Individuals with Disabilities Education Act, or IDEA, mandates that children with disabilities receive adequate and appropriate education and hold schools accountable for providing services to meet their needs. And again, this is any school that receives federal funding. And that includes colleges and universities. So here are the 13 categories that are covered under IDEA. There's a link for a comparison chart between how IDEA and how Section 504 differ and the protections that they provide to students. I want to talk about duty to warn and duty to protect for a few minutes. This is certainly something that can be applicable if we're working with adults. Not as much with kids, but definitely adolescents. If we have to warn or protect others, then our adolescent client has told us they're with somebody else. So there's 3 requirements for Tarasoff. Information is communicated directly to the therapist by the client or the client's family member. So the client or a client's parent tells me, I'm going to go blow up my school, or my child says they're going to go blow up their school. A serious threat of harm to self or others is imminent, and the potential victim can be reasonably identified by the therapist. If those 3 requirements are met, we have to notify potential victims, notify authorities, and take steps to prevent threatened danger. I haven't had this happen with an adolescent, but I did have it happen with an adult client who disclosed a plan with intent and means to go shoot her boss at work. So she met all 3 requirements. I notified the victim. I had to call her boss at work and tell him. Confidentiality was waived at that point in order to protect the victim. I had to notify law enforcement. And then number 3, the steps I was able to take to prevent threatened danger. I had the client assessed for inpatient treatment. What happens if your adolescent client says, I'm going to hurt someone, but they don't tell you who the person is? You can still notify, if you can't reasonably identify the potential victim, you can still notify the client's parents. If you know that person, that potential victim, attends school with the client, you can let the school know. You can notify the school. So sometimes we don't know specifically who the victim may be, but we have to take any step we can to protect potential victims. I'm going to let you guys take a few minutes to look over tort negligence and malpractice, to focus on what malpractice is, what a standard of care is, and the elements that must be present in order to prove negligence. When we work with adolescents, we have to remain abreast of parental rights and custody laws, because there can be questions as to who can provide consent for treatment. Like my adolescent female who came in at 16, who said my grandmother will sign for consent from treatment. However, her grandmother was not her legal guardian. There was an informal family arrangement, but no legal arrangement. So there were questions as to who could provide consent. When there are legal rulings regarding custody or removal of parental rights, we are charged with finding this out up front. So we ask questions in intake. We ask questions throughout treatment. If we are hearing about changes in custody and parental rights, but we can only do as much as the parents are honest with us. We need to get authorizations for release of information for step-parents, grandparents, parents, romantic partners, etc. And this can be awkward if we have a grandparent who's helped raise this adolescent, if we have mom's romantic partner who was like a father to this adolescent. But if this individual does not have legal custody of the adolescent, we need to have the guardian sign consent for us to communicate with other members of the family. So if you're at intake and mom and stepdad come in, you're going to want to have mom sign a release for stepdad so that he can be as involved in treatment as mom wants him to be, as you want him to be, as the adolescent wants him to be. If grandparents play a big role in this adolescent's life, you want to have the guardian, the parent who has custody, to sign a release of information, allowing the grandparents, allowing you to communicate with the grandparents. Even when people live in the same home, even when people have been in relationships for years and years, If they don't have legal custody of the adolescent, we have to have a signed release from the parent in order to involve them, communicate with them in therapy. Both legally and ethically, the protection of minors from harm takes precedence over privileged communication for mandated reporters, which we are mandated reporters. All instances of suspected abuse and neglect must be reported to appropriate authorities. Must inform the client and parents of a duty to report at the beginning of the counseling relationship. It's part of your intake session. When we work with adolescents, we need to be competent to do so. And that's part of the ethical standards for the American Counseling Association. The authors of our book suggest that counseling adolescents is a specialty area that requires additional education and training. Knowledge of developmental ages and stages, developmentally appropriate interventions, the ways in which psychological disorders manifest themselves in adolescence, and culturally centered and family-centered approaches are some of the specialized knowledge counselors should obtain. What about when we need to share information? So if we need to share information with a school or a doctor, we have to have permission from the caregiver or the guardian. And we also want to talk with our adolescents so they understand why we want to talk to a psychiatrist. And we want to protect their confidentiality as much as possible. So we're only going to release information that is relevant to treatment. We also need to be mindful of the difference between disclosing and informing. It is often possible for us to inform caregivers or other professionals without breaking confidentiality. We're seeking to balance to protect the therapeutic alliance while being ethical and providing effective care. So I can give the parents a treatment update about what we've been working on in therapy. We're working on anger. Here are some coping skills we discussed. We're working on anxiety. Here are some connections that we've made. Most likely, I've already talked with my adolescent client, so we're on the same page about the information I'm going to share. I can inform the parents of treatment progress and treatment focus without disclosing confidential and private information the adolescent has shared with me. So what happens when we have a parent who wants information and we're not quite comfortable with sharing it? So our first step is to talk with the adolescent client about the request to see if they're open to sharing this information with the guardian, with the parent who asked for the information. We're also going to talk with the adult about how it's not serving the adolescent's best interests to disclose that information, how it can impact the therapeutic alliance, how it can impact the relationship that the parent has with the adolescent. If neither of these approaches is successful, we can take the next step and conduct a joint meeting with the parents and the minor, where we will serve as a facilitator and hope that the adult changes his or her perspective about wanting that information, or that the minor will become comfortable sharing that information. If at this point you have not reached a successful solution, you may inform the child ahead of time and then disclose the content of the session to the inquiring adult. Oftentimes, going through these steps, a solution is found and this is resolved. Sometimes it's parents not being educated about therapy, about therapeutic alliance and how important that is. Sometimes it's an adolescent not realizing how important it is that they share certain information about their thoughts and feelings with their parent. So maybe their parent really is just wanting to know how the client is doing. How is my child doing? So helping the adolescent find effective ways to communicate her experience so that her parents don't feel like the only way they can get that information is by demanding session records. And here's a visual of those steps. And once again, I'll say always consult. Always grab a colleague from across the hall or bring this up in treatment team and get other people's input, how they would handle it, how they've handled similar situations in the past as you're making these difficult decisions.